We're going to have a little bit of fun today. We want to talk ever so slightly about the Constitution. And you're in the right place. You're with Mr. Constitution Man. And I have to deal with the left, which in the aggregate are called Mr. Constipated Man. But that for another day. So Jonathan Turley and a few of us are in a little bit of a hubbub, all friendly, all respectful. There's a writer in Newsweek, I'm afraid, who really doesn't understand what she's talking about. That's okay. So let me do this in a way that is in plain English and starts from the top. Given what the Biden administration is doing to President Trump. Let's say President Trump gets elected president. And he still has all these indictments against him. Or, in one of these jurisdictions, he's been convicted by a jury, none of his peers, of Democrats. What then? Well, we look at the Constitution of the United States, don't we? What does the Constitution of the United States say about this? Absolutely nothing. Because you see, the Constitution was written for virtuous people. And a virtuous people serving in their government. It wasn't written for Joe Biden and Jack Smith and Fannie and the knucklehead in Manhattan. It was written for people who have virtue, and they have none. So now what do we do? Well, some of the ground has been laid here in the past, 1973, and in 2000. What do you mean, Mark? The Department of Justice in 1973, in the administration of Richard Nixon, had to take a look at this in case Richard Nixon was indicted. And the Office of Legal Counsel, which is the brain trust of the Department of Justice, the office that looks at these issues, gives advice to an attorney general and a president. Look very carefully at the pros and cons. And of course, it acknowledged there's not much in the Constitution that helps us, and there's certainly not much in our history that helps us. Even at the Constitutional Convention, there's nothing on this. So they looked at it, and they went through it very carefully. And I read it. And they concluded, no, not because the Constitution compels it, but you really can't or shouldn't indict a sitting president. Well, why? Because you will wind up decapitating the executive branch. You will undermine the voters who voted for that president. They didn't vote for the vice president to become president. They voted for that president. You will endanger America's national security. You will do all these things because a president cannot possibly effectively be a president and at the same time have time to defend himself and keep himself free. Any citizen would have difficulty doing that, let alone a man who's the head of the executive branch, and in fact is the executive branch. He's 1/3 of our government. Moreover, there are other issues like how would he be able to negotiate with other countries? He'd have no respect whatsoever. And what if he's convicted and he winds up in jail? Then what? Well, you can always impeach him. Okay, great. But what if you can't remove him? So impeachment is the process by which the framers of the Constitution set up a constitutional / political process for removing a president, not a criminal process. And so they concluded in 1973 that using the best thinking and reasoning and practicality that we possibly can, that the official position of the Department of Justice is no, you cannot and must not indict a sitting president. You cannot allow a prosecutor and a grand jury and then later a prosecutor and a trial jury and a judge to determine the outcome of not just an election, but also the decision about whether you remove a president or not. Can you imagine having a prosecutor and a jury deciding if a president stays in office or not? So this is the opposite of democracy. Which leads us to Donald Trump. If Donald Trump is elected president, the same argument applies that was argued in 1973 and 2000 that essentially went through all those arguments as well and effectively rubber-stamped the position the government took in 1973. So we have a Democrat Department of Justice and a Republican Department of Justice saying no. You really can't indict a sitting president unless you want to destroy the constitutional construct, and moreover, you're violating his due process because he can't possibly defend himself. You know, he has to sit with his lawyers for hours at a time. They have to go over depositions. They have to go over documents. They have to go over exculpatory information. They have to go over now texts and emails and on and on and on, videos, perhaps 1 million documents, 9 months of videos. That's just one case here. Just one case. And so the fear also was you would open the door to the kind of activity that's taking place today by the Democrat Party. All right, let's stay focused. So does it follow that a president can pardon himself? We don't know. President has never been indicted. A candidate who wins the presidency has never been indicted. Can he pardon himself? Again, you have to look at what is rational, what is practical, the impact it has on the nation. Because the Constitution doesn't tell us. There's nothing to stop a president from pardoning himself. That's number one. Certainly not from federal charges. So, given the conclusion of the Department of Justice under different administrations in 73 and 20, that you cannot indict a sitting president, then the conclusion logically follows that a sitting president who is indicted can pardon himself. There's no reason he can't. Now here's the next shoe on this. Having read this opinion in 2000 that includes the 1973 arguments and their own arguments, and they conclude, look, you cannot indict a sitting president because of the dangers the nation faces, because you will decapitate the executive branch, you will cripple the ability of an elected president to function, and on and on and on. The question is now, if the Georgia indictments stand, and Donald Trump's elected president, can he pardon himself from these state charges? The truth is the Constitution doesn't tell us. In fact, neither do the memos from the Department of Justice. But the Department of Justice, those memos do tell us something. What do they tell us? That the reason why it's the Department of Justice's position to federal prosecutors that you cannot indict a sitting president is because the dire circumstances that could create in our constitutional system with a decapitated executive branch and without the president being able to defend himself. That's their conclusion. That's all there is. It's a rational argument. Some might even call it an equity argument. Whatever the argument is, that's it. So the question then becomes, and I've heard Jonathan Turley say this, perhaps some others, I don't remember who they are, and I have nothing but respect for him, by the way, but a president cannot pardon himself from state charges. Why is that? Well, a president doesn't typically, in fact, he doesn't at all, reach into state charges or convictions based on state law and state judicial systems and pardon people. It's a federalism thing. We just don't do that sort of thing. And my point is that is wholly and completely irrelevant. That has nothing to do with what the Department of Justice said. We're not talking about Ernie Grabotsky down the street. We're talking about elected president of the United States who is the executive branch. Not a guy who's been embezzling funds from a bank and then a president decided, I feel bad for that guy. I'm going to pardon him. So I would agree. No, the president does not have authority to do that. But does he have the authority to pardon himself for the very reasons the Department of Justice said? That you cannot indict a sitting president at the federal level? Am I making any sense to you so far, Mr. Producer? Well, let's step back and take a look at this. Since we're not really talking strictly about the Constitution, we're talking about what happens to the Constitution. Let's step back and take a look at this. There are literally thousands of DAs and assistant DAs, state prosecutors, and local prosecutors all across the country. If it is the position that Fani Willis and Alvin Bragg and the others can get away, let's say, prosecuting Donald Trump, even if he's elected president, what do you think would happen to the country then and thereafter, Mr. Producer? In other words, the exposure to destroying the executive branch and the federal constitutional construct is 1,000 times worse. So clearly it's an important federal constitutional matter, is it not, America? And surely, let me even throw in Article 6, the Supremacy Clause would apply, would it not, America? As applies to the President of the United States, not Ernie Grabotsky, the embezzler, the bank embezzler in Atlanta, Georgia. I'm not talking about him. And neither was the Department of Justice. They were talking about if hypotheticals involving a president of the United States. How can it possibly be, as a matter of practicality and logic, that the position of the Department of Justice is you cannot indict a sitting president, and it follows from there that he can't pardon himself, except if you're a state prosecutor or local prosecutor, then prosecute away. Go ahead. Do it. That can't be right. That makes no sense. So we have a clause in the Constitution that helps us work our way through this, the Supremacy Clause. And the president does have the pardon power. And so it would follow, it seems to me, without much argument. These are all novel questions because of what the Democrats are doing today. They're all novel questions, but there are better answers than others. It would certainly follow then, based on the conclusion the Department of Justice reached in 1973 and in 2000, that states cannot indict a sitting president, and that if a candidate running for office is indicted and becomes president, that the president can in fact pardon himself. With or without the Supremacy Clause, I think the Supremacy Clause makes it stronger, but for the same reasons that we say federal prosecutors can't indict the president and that a president can pardon himself from federal charges. It's not that complicated. And it's certainly the much stronger argument than the one our friend Jonathan Turley is making.